A very good evening to you, ladies and gentlemen. I am happy to welcome you to the 17th webinar of Series 6 on Basics of Law titled Matrimonial Actions. This is the 51st BSL webinar for the years 2025-2026. This webinar series is organized by the Webinars and Legal Symposiums Committee of the Bar Association of Sri Lanka. I would like to take this opportunity to thank the Chairman of the Webinars and Legal Symposiums Committee and the President of BSL, Mr. Rajiv Amarasuriya, the co-chairman, Mr. Chatre Galhena, Secretary of BSL, and Mr. Pasindu Silva, Treasurer of BSL, and the conveners, co-conveners, and the members of the Webinars and Legal Symposiums Committee. I would also like to extend my heartfelt gratitude to the Executive Committee of the BSL for all the support and guidance. For today's webinar of Matrimonial Actions, we have with us an esteemed panelist, Ms. Jerusha Krosetambaya. Ms. Krosetambaya is an attorney at law of the Supreme Court of Sri Lanka with more than 14 years of experience in the civil and quasi-criminal sphere, with a special focus on family law, sexual and gender-based violence, and commercial arbitrations. She holds a diploma in law from University of London, advanced diploma in psychology from American College of Higher Studies, Bachelor of Laws Honours from University of London, and a Master of Law from University of West London. In addition to that, she is also a mentor and student counselor and the lecturer in charge of family law and tort law at CFPS Law School. Ms. Krosetambaya is also a panel lawyer for the iPro Bono Legal Network, panel lawyer for Pratya, panel lawyer for Legal Action Worldwide, and a member of the Board of Sri Lanka Unites. I warmly welcome Ms. Jerusha Krosetambaya, attorney at law, for today's session. To moderate today's session, we have with us Ms. Shevindri Manuel. Ms. Manuel is an attorney at law of the Supreme Court of Sri Lanka and the program manager at iPro Bono Sri Lanka. She holds a Bachelor of Laws from University of London and a master's degree in Justice and Criminology from RMIT University. Ms. Manuel is deeply committed to driving impactful change through strategic program oversight and effective management skills, and is driven by a profound belief in the power of legal advocacy to transform lives and build a more equitable society. I also warmly welcome Ms. Shevindri Manuel, attorney at law, for today's session. And without any further ado, I invite her to commence today's proceedings. Over to you, Shevindri.
Thank you, Isri. So today we'll be delving into a topic that sits at the heart of both private life and public justice, matrimonial actions. Really excited to have you on this panel, Jerusha, because we know that you do a lot of work in this field. So our matrimonial laws here in Sri Lanka, some date back over a century. They were written in a time when social norms, gender roles, and family structures looked very different to what they are today. But even as society evolves, the law remains the foundation that governs how we enter into marriages, sustain it, and when necessary, bring it to an end. In a sense, matrimonial actions form the bridge between personal relationships and the legal system, ensuring that something as intimate as marriage is also recognized, regulated, and safeguarded by the law. Our goal today is to understand how the law can protect both the sanctity of marriage and the dignity of those who seek to end one, balancing tradition and modern values with justice and empathy. Together with Jerusha, we'll be unpacking the legal framework of marriage in Sri Lanka, the grounds on which marriage can end, the social and cultural pressures that shape how matrimonial issues are experienced and handled, key concerns such as domestic violence, custody, and access to justice, and how these areas can be strengthened to reflect fairness, compassion, and also equality. So moving into marriage in Sri Lanka isn't governed by a single law. Instead, it operates under a plural legal system, reflecting our country's diversity of cultures and religions. Depending on your community or your religion, you could be governed under the General Marriage Ordinance, Kandyan law, Muslim laws, or Tesavalame laws. Each of these frameworks define how marriages are registered, recognized, or even dissolved. So my first question to you, Jerusha, is, could you explain how these systems that govern personal laws differ in terms of marriage registration and recognition?
Thank you, Shevindri. So as you said, we have a plural system with multiple forms of registration, both customary, and there is a registration process also, General Marriage Ordinance. Now, these are deeply reflective of the different communities and the kind of culture that we have. For everyone, there is an opportunity to be governed by the General Marriage Ordinance. And for this, there's a 3-step rule sort of, where you need public notice for 2 weeks. this came about because back in the day, people would have different wives in different towns and nobody would know, kind of thing. So here you have to publicly notice that you are getting married, so somebody has an opportunity to object to it, because bigamy is not something that is accepted by our laws. Then this also leads to free consent. Nowhere in this marriage registration process can somebody be under duress when they are signing. So it is by way of free consent. And also there is a formal registration process before your area registrar that you can sign this kind of document. So that is the General Marriage Ordinance. What is good about this process is that it makes you eligible to come to a regular Sri Lankan court and be governed by protection orders, domestic violence laws, to automatically be able to come under inheritance and intestate succession, people's wills if they die without a will. How will you then, if you're married, how do you inherit automatically? How do your children inherit automatically? Then it makes children legitimate. I don't like this word because I don't think there is anything called legitimate child. It's just adults who are messing up legitimacy. But by way of marriage, it makes every child then automatically legitimate. And also then it gives you rights where you can enforce maintenance, custody, property matters, all within the scope of a general marriage registration that you have. These are the benefits of the general marriage registration. Aside from this, Sri Lanka's key cultural groups have their own customary ways of having a customary marriage. Kandyan marriages are divided into two, Diga and Vinna. Diga is where the woman holds her rights to property and the man moves in with her. The Vinna is the other way around, where the man retains his rights and the woman gives up her rights at some level. Then we have the MMDA, the Muslim Marriage and Divorce Act, where you don't need public notice, where even children or girls under the age of 18 can still, with their father's consent, be put into a marriage. It's governed by the Qazi. Even the civil registration is done under the Qazi, and even the divorce is handled by the Qazi court. And they have the triple talaq system, where a man can leave a woman under this system. So this is the MMDA. Then we have Desa Valama, which is generally enforceable for people from the northern region of the country. And here a married woman can't hold land without the consent of her husband. So you see in Desa Valama and MMDA some things that are a little less progressive. Canadian option has both. But everybody needs to come under the General Marriage Ordinance also to make something legally enforceable in a court of law. So these are the different aspects that are available to us.
Okay, thanks for sharing that. I feel like that was a lot of information, and it sometimes can be tricky, I think, to figure out where exactly these personal laws apply or customary laws would apply. So could you maybe give us a little bit of information about some of the common mistakes or misconceptions people have about marriage registration and the process that's involved?
So, for somebody who practices in family law, a lot of times people have only done the customary aspect, and then they come and they're surprised to know that they have no way to pursue things legally because they have forgotten to do the registration process. Another thing they may not understand is that you need to have the due notice period for marriages. Even in some customary Christian forms, there are bans that you have to take, and in the General Marriage Ordinance, there are days that you have to give notice. Otherwise, that also affects your registration. Then they don't generally give the proper documentation for like birth certificates, identity cards, and things like that, which hampers their registration. And another thing is they sometimes ignore personal laws instead of doing it together. So these are some of the common mistakes. They also think things like property rights and citizenship automatically comes to you if you have registered a marriage, which is not so. Those are a step further that you have to process. So these are some of the things that people are confused about when they register or fail to register a marriage.
Thank you. Thanks for sharing that. So before we dive deeper into annulment, divorce, and domestic violence, I think it's important to recognize that matrimonial issues in Sri Lanka are not just legal matters. They're profoundly shaped by culture, tradition, and also social expectations. From the moment a marriage begins to the difficult decisions around separation, families or communities exert influence, often dictating what is considered acceptable, honorable, or proper behavior, especially in the South Asian region. These social pressures can affect whether people feel able to seek help, assert their legal rights, or even speak openly about their marital problems. With that in mind, I'd like to ask you, how do cultural and social attitudes in Sri Lanka shape the way that marriage, divorce, and other matrimonial issues are experienced or handled?
So, because of how culturally entrenched this concept of marriage is, there is a lot of focus on traditional gender roles, and that affects. So, a house husband is a role that a lot of people won't accept, and things like that really affect how a dynamic between a marriage then happens. Another thing is this family honor. A lot of cultural marriages specifically, it's almost like they can do away with the life of a woman if she has somehow stained the honor of the family. So those things are still extremely entrenched in rural areas, and these things still happen today. The other thing is that regularly, or almost often, women are seen as primary caretakers, and her role is to sort of preserve the family. And so she's economically dependent on the man. And then this is used as a bullying tactic, or she can't come forward if there's violence, like domestic violence, and she can't. Sometimes there's a lack of literacy, there's a lack of psychosocial support, and so then this hampers a woman's access to justice. And so these kind of old school rules, I think till very recently, there was a very popular video of the police also circulated, where a high up police officer said um, about how there are minor beatings and major beatings, and you should be sent home and things like that. So culturally entrenched from this English British Bible principle is this buttressing of marriage, which is not a bad thing, but not at the cost of somebody's rights and not at the cost of violence itself in the home. So these kind of traditional rules and biases keep people in these kind of toxic marriages, which then lead to other things, including a very high level of homicide that take place in these homes. 1 in 3 women who are murdered are generally murdered by an intimate partner. And so then we see that this kind of social norms and this kind of social pressure leads to these kind of things.
Okay, thank you for that. And I agree with you. I think our culture kind of impacts how we get into marriages, and also how even during the marriage it can be heavily influential. So next I want to move on to dissolving a marriage. Just as the law provides a framework for entering into a marriage, it also provides a framework on bringing that marriage to an end. Dissolution of marriage, whether through an annulment or divorce, is one of the most sensitive and complex areas of family law. It's where personal emotions meet legal procedures, and where the law must carefully balance compassion with justice. First, I'd like to touch on annulment, another but less discussed way of ending a marriage. Annulment is not the same as divorce. It declares that a marriage was never legally valid in the first place. So I'd like to ask you if you can explain in what circumstances a marriage can be annulled under the Sri Lankan law, and how it would differ from divorce.
So what I want to set out at the onset, because we were talking about biases and gender pressures and stuff like that, even annulment is a concept to sort of say that it didn't happen, so that you don't have a failed marriage. My biggest problem as a family law practitioner is that this whole marriage concept and divorce is looked at as a failure. It's not an exam, it's human relationships. And there are multiple reasons. They always say there is her story, his story, and the truth. So there's always all sides to it. And so treating it like some kind of win or lose then is reflected in how contentious the divorce becomes. So annulment is another way to sort of say, oh, if you annul a marriage and it never happens, so then you don't have a record, you don't have a bad record. So that also again is another kind of gender bias, where people think if you have an annulment, then you have a clean record. Annulment itself is within our laws. That's also something that we've gained from British laws itself. But for very, very few and tight reasons is where you can come within this scope, right? It's about section 18 to 24 of the General Marriage Ordinance. One is lack of valid consent. Either if you are insane, or you're not able to give consent, age issues, or you didn't know what you were doing, then marriage can be annulled. Because about something very important about marriage is that you have to get into it with free consent, and anybody can contract a marriage. It's not often that you need to check whether they are the same education level or monetary standards or class or caste or anything. Anybody who's in agreement can get into a marriage. And British law, there are case law to show that you don't have to have a high intelligence level. If you can understand basic principles, you can understand getting into a marriage. So if there's lack of valid consent, that is one grounds for annulment. Then there is bigamy. If you are married a second time without properly dissolving your first marriage, that is seen as a criminal offense also. There's a criminal procedure that can be taken up also against the parties, and it's also a grounds under annulment. Prohibited relationships where certain family members, the first line, your most close family members like parents and children, siblings, even some step relationships, things like that, direct relationships make a marriage void. You cannot have a marriage between parties that are prohibited. England has a vast amount of groups. We have a smaller amount because traditionally, in order to keep our lands within the family and things like that, there were uncles and nieces married off and things like that. So we are not very strict with those relationships. But in terms of parents, children, siblings, that kind of thing, it is, and grandparents, grandchildren, that kind of thing, they are very strict about the fact that that then becomes a prohibited relationship and you can annul a marriage. And the fourth grounds for annulment is impotency at the time of marriage, right? It wasn't told to the other party. And this is another why they look at it is because of one of the key factors of getting married is to reproduce, and then this stands in the way. So this is another grounds that you can annul if you had no idea, no knowledge of the impotency at the time of the marriage, right? If you didn't have the woman did not have any idea of the man's impotency at the time of the marriage. Finally, fertility doesn't come into play here, but impotency does. Just before we go into, I know your next question you said would be on divorce, but before we go into that, aside from annulment, another way to dissolve or to bring to an end a marriage is judicial separation. It's not something that is done too often. I think us as lawyers also, we don't really recommend it too much. Why it came about is for some religious beliefs. It's important that divorce is seen as a sin and things like that. They prefer to be judicially separated. They are the owners. What you have to prove is much less than a divorce. You have to show that the way that person behaves has now or has done something, they have done something unlawful to you, or the way they behave that now you cannot live with them anymore. Cohabitation cannot be expected of you. And so then you can't marry again and things like that. But it, in terms of like a separation, it's validated by a court order.
Thanks for sharing that, Jerusha, and thanks for sharing about judicial separations as well. Now I'd like to dive into divorce. This is the dissolution of marriage. Under the General Marriage Ordinance, a divorce can only be granted under 3 fault-based grounds: adultery, malicious desertion, incurable impotence at the time of marriage. So these are very colonial concepts brought in by the British. They make divorce adversarial, lengthy, and it can be a very emotionally harmful process, forcing couples to assign blame instead of allowing them for a dignified separation. So my first question to you on divorce is, could you explain how each of these grounds operate in practice and what challenges couples face when trying to prove them in court?
So, like you said, the fact that we are contained to these limited 3 grounds has been a big issue with our laws, and there are lots of reforms that lots of us sat on different committees and push forward, including yourself, and that has still not gone from bill stage to legislation, unfortunately. So we are still stuck with these 3 forms only and a fault-based system. Something like divorce itself, like the British judges say, I remember a quotation that said you must crush the eggshells and move on, is not something where you should have a bitterness when you're moving on, because sometimes you might have to co-parent. Sometimes you might still have to be in each other's lives. And the fact that there is a lengthy adversarial process to your divorce then doesn't help you with the healing and moving on. Adultery had a very high standard, beyond reasonable doubt, that you had to prove that there was some kind of physical relationship. There is later cases that have come about to show that no, it has to be even circumstantial evidence is enough as long as you can show that this has happened. It's a slightly lower standard now for adultery. Often people don't go on that grounds unless they have very good proof because of the high context in which it was handled previously. Malicious desertion has 2 parts. It has the general malicious desertion and then the constructive malicious desertion. Malicious desertion itself is that somebody left the marriage, didn't want to work at it, and there is no coming back. So then the other person can stand on that person's leaving. As in, the one spouse can blame the other spouse for leaving. Constructive malicious desertion is probably the most broad area that most lawyers use to show that that person's behavior has caused you to leave, and now there is no way that this can be reconciled. And then we have incurable impotency again, which is limited to a medical condition, and that has to be proven in that format. The fact that this is the only 3 ways you can get out of a marriage then traps people into marriages and makes it extremely inefficient. And this process can, I was once, I think in one of our local, like one of our bars just outside Colombo, and I was told that a divorce had gone on for 20 years, that the mother and the daughter had also filed her divorce and they were coming to court on similar dates. So when it's like that, then there is no reason for people to get into it, and it makes it extremely bitter and lengthy, and people really don't like to sort of enter even or take a decision about a divorce because it's so inefficient. The good news is that a lot of lawyers practice some kind of mediation, and a lot of people understand that because it's a family matter, they don't want to make it ugly. And now with mediation becoming more legitimate and something that we can use in courts, I hope that most family law cases will be looked at in that fashion before we go into a real lengthy adversarial system.
So thanks for that. Like you said, there is too much of a burden when having to prove one of the fault-based grounds for divorce. So my next question is, should Sri Lanka recognize the right to exit a marriage that has broken down even without fault?
So as I touched on previously, as we sit here today, there is massive amounts of reform bills that sit not change into legislation. And one of the key things that we put forward was this no-fault divorce, because we followed England somehow. We have customary laws that reflect our other communities, but we somehow followed a Christian-based country. And so that they were very heavy because the Bible says divorce is a sin. The Church of England originally was very harsh with anybody getting out of a marriage. So then they wanted to buttress marriage, and then they had very few reasons that you can get out of marriage. But England themselves have now moved on to a no-fault system. But now we are still stuck with this fault system. Yeah, even if 2 people come to you and they are amicable and things are okay, you still have to file. I've had cases where, because we have nothing else to say, they've said the woman doesn't make me tea, and the woman is like, how dare he say that? I have made tea for him every day. So, it still offends people. It's still personal, and it makes it very, very unpleasant. So because it's still not law and the registrar is not accepting of it, these grounds of irretrievable breakdown of marriage, just the general grounds was enough to get a no-fault divorce, where you don't have to prove anything. You can just say that my marriage is irretrievably broken down. Both parties are sort of consenting to it, and it's a simpler process. We also don't automatically enforce foreign judgments in our jurisdiction, which means even if you've gotten something in another jurisdiction, you have to still come here, point a finger at somebody else, and get yourself a divorce. So these are the things that don't then help you reduce hostility. No amicable settlements. It doesn't protect your privacy. All your dirty linen is washed in public. And it doesn't enhance access to justice in the sense that people are afraid of coming here and getting into trouble and fighting with their spouses. And so this then delays access to justice in a very big way. That being said, I know a lot of people who are against the no-fault system are talking about, if you make it easy, then where does the sanctity of marriage lie? Which is also a thing which I'll come to later. But I feel like the sanctity of marriage should lie in their hearts and not just a law trapping you in some kind of marriage. So for now, a no-fault system would be something that would be very useful, which we don't have as yet in legislative form.
Okay, thank you. Thanks for that, Jerusha. And now we're moving on to domestic violence. As you know, domestic violence isn't currently a ground for divorce under Sri Lankan law, and this is a significant gap, leaving women exposed to intimate partner violence. The Prevention of Domestic Violence Act of 2005 allows victims or anyone on their behalf, including the police, to apply for protection orders. These orders are civil in nature. They don't criminalize domestic violence itself, but breaching a protection order is a criminal offense. This means that a person may be legally protected from abuse, yet still be bound to the marriage that causes harm to them. It raises a serious question about how the law defines safety, dignity, justice within the institution of marriage. So, in your opinion, do you think that domestic violence should be a ground for divorce?
Thank you, Shavindri, for that question. So basically, like I told you, we are limited to those three grounds. And one of my favorite judges, the late Prasanna Jayawardena, in one of his judgments, Gomes versus Gomes, I believe he was the judge that wrote this dissenting fact, that in this particular Gomes versus Gomes case, this woman had been married for several years, she had grown up children, the divorce itself, I think, went on for many years. But she had alleged malicious desertion. And then she had alleged some cruelty towards her. But she had not really been able to prove that cruelty. She had not brought enough evidence. And so basically, the divorce was not given. There was an incident of severe violence that she had alleged, not enough proof, and it wasn't given. And in that, I remember Prasanna Jayawardena, Justice Prasanna Jayawardena, asking for reforms in this area and to consider cruelty, because cruelty by itself is not enough. If you have gone back to living together, then this desertion factor doesn't come into play, basically. I think something like domestic violence should be a standalone grounds, because otherwise that puts a lot of people in severe danger. And the fact that this Domestic Violence Act goes one way and the marriage the marriage ordinance doesn't even cover this is a real problem, because then you have to come into, so what if there's an abuser who doesn't want to leave and says I will stay in the marriage, then what are you going to show? And constructive malicious desertion also, there's a high burden for you to prove, and sometimes incidents in the home very difficult to show that kind of proof. No one's recording all the time what's happening in a private home. So in that sense, I would say that it's absolutely timely in the reforms. Also, it has been suggested that this be a standalone area. I'm not saying that, a lot of the times people say we look at domestic violence as this, if some one-off thing happens. I understand that marriages are long and they're different for everybody and there are compromises. But if there's enough to show brutal cruelty in a marriage, it should be enough for you to leave a marriage itself. So it should be made a grounds.
I completely agree with what you're saying. I think it should be a ground for divorce too, especially considering that in our work, we see a lot of cases of domestic violence where women are stuck in very abusive marriages and don't have a way out. There are situations where even the police haven't been very supportive to support women to even get protection orders. There's always this go back home, this is a personal issue and we can't really get involved. So I also want to talk about the family courts and how they're under-resourced and slow. There is limited access to legal aid, especially outside of major cities and in rural areas. Marginalized women face cultural and financial barriers when filing cases. There is also a lack of specialized family court judges, trained counselors, and support staff to handle sensitive cases such as domestic violence, divorce, and things like that. So how can we make sure that we enable access to justice in matrimonial issues?
Thank you, Shavindri. So one of the key things that we've always spoken about, and I remember, I think it was Salih sir was president at that point, we were talking about family court should be more like a round table sitting where people actually try to mediate and bring some kind of closure to this marriage, because unlike a commercial matter or a criminal matter or whatever, there is no winner or loser. Everybody is at some level losing something in these proceedings. So the fact that we are based like this big fight where people just pay lawyers to come and yell at each other will not really enhance justice in any way, and it will keep a lot of people from coming to these courts. So I think the first thing is that I know we are highly under-resourced. And I saw even recently, I saw the government is trying to put forward 3 more high courts, and a lot of people are asking questions, how when we don't have enough staff. So I get that it's not always practical. But to have a separate family courts always just handling only those matters is important, and it should be styled in a more amicable manner. And mediation or some kind of settlement conversation should be made as compulsory before everybody comes. I see that judges always try to advocate for that. I see a lot of lawyers really supporting that kind of conversation, but there is nothing to nothing legal or nothing in black and white to follow. So if family law can be handled in that way in a separate structure, that is one thing that would help. Another thing is pro bono support, gender budgets, legal aid commissions to support these kind of matters, because everybody knows litigation is extremely expensive, and one thing that keeps a lot of victims and even people coming from courts is the cost. So that kind of thing, an allocation for these cases is important. The other thing is, and I can't say this enough, it's gender sensitivity training. Not only for us and the judiciary, not only for the profession and the judiciary, but even the other stakeholders like the JMOs and the police and the media. All of us need to be trained, because sometimes I see matters where recently in a matter somebody took a tool to this woman's head, and the defense on the other part, and that woman's head was in a state of frozenness, as in her cerebrally and neurologically her brain was frozen, which is a very serious injury, and she wasn't allowed out of the hospital for a long time. The defense's argument was, she's a loose character, she's going with other men, so this is what happens. So if you are going to now somehow justify this brutal violence with someone's character, and those arguments are allowed, one thing is women won't come forward. Men also. But mostly this happens to women, so women won't come forward. And number two, nothing justifies this kind of action. If your spouse or somebody is cheating, get a divorce. Leave them. Call them out. I am not in any form supporting that kind of thing. But you can't justify brutal attempted murder level violence because of their character. So this kind of lack of gender sensitivity, even with rape victims, we see that people come and ask the most heinous questions and somehow think that if there is some character issue that they can bring, that you are now somehow justified in being raped, which is ridiculous. What were you wearing? Where were you going at this time of night? That's the kind of thing that all of us need to be trained in. So that's very important also. And mediation, community awareness, and psychosocial health. I know our family courts have counselors, but we need to do better than that. The psychosocial help needs to be number one. Everybody needs to be able to reach out and get that kind of help. And mediation, I'm a big fan, especially for family law, because like I said, there's no winners. And I always think of it from the point of view of the child. And so then I think if these parents, I mean, you need to go to the child's graduation together, you need to go to the child's wedding together. And if you can't stand each other and look at each other, everything becomes worse for everybody. So I think family law has to be handled, matrimonial actions, marriage and divorce have to be handled in a very different way. And so if we encourage mediation, we encourage counseling, we encourage this kind of special route, then things will be much better and access to justice will improve by and large.
You make some really interesting points there, Jerusha. I think when there is a dissolution of marriage or a divorce, and when it gets really ugly, it's the children that suffer the most. And then there's a whole issue the issue that arises is on custody. Where did the children go? And under the current law, custody decisions are made in the best interest of the child. But they often reflect traditional gender assumptions, with custody defaulting to mothers and the fathers facing enforcement challenges for visitation or maintenance. So how can our courts better protect children's welfare in broken families, both emotionally and economically?
So good you ask this question together, because I feel like our Domestic Violence Act is pretty good. Our divorce laws are under reform, getting better. But maintenance and custody seem to be the most difficult to litigate in a justiciable and in a sort of fair way. It seems like it's not always fair. So maintenance, the issue we face is we are not a digitized system, very hard to find out somebody's salary. Everybody who's a respondent in maintenance court will say they have nothing to give the child, and our quantums and our orders seem to be not in line with what expenditure and cost of living is generally. As I said, the judges do their best, they're trying to do better. They look at lifestyle, your resources, your needs, your assets, what you have, and try to give the child a similar lifestyle, or the wife themselves who have not worked and have a right to maintenance. But maintenance itself seems to be a very troubled area because you're unable to prove what the person's employment is unless he's in some formal sector where we can get a monthly salary. Now, and best interest, like you said, is something that you have to follow. Custody is the other area that I find very painful because the child is used as some kind of pawn in this game, some kind of object. Everybody is pulling at them, pulling at the child. Nobody cares except for some ego battle there. And often the child is the last thing they're looking at, and it's such a ugly situation. Two people who live together in a home, who slept together probably with this child in the middle, are suddenly like the other person can't see the child. There is genetically also these two people have now created this child. I don't understand why all of a sudden it becomes such a problematic area that they can't see eye to eye. And the other thing you remember is it's only till the child is 18. And if you behave like this, most often, I remember a very senior counselor saying this, and now I say this to my clients also. If you behave like this at 18, your child is going to tell both of you all to get lost because you have caused so much pain to that child. So our custody laws are not bad. We have the Judicature Act, we have the CPC, we have 621 applications, all of that is fine. But always used as a legal ploy, always putting the child in some kind of harm, embarrassing children in school. Parents do some really weird, I get it. There's a lot of pain, there's a lot of hurt, there is a lot of you feel this sense of loss and you don't know how to behave. But when you have children, I would expect then that to make it better, for you to be thinking clearer. And access, I don't think should be denied unless there is some potential harm to the child. And I don't know why we fight so often about access itself. But number two, even custody wise, I think it should be handled much better, and there should be very little tolerance for people using this as a tool to win some kind of ego battle, which happens way too often. And even judges get really frustrated, and it takes so long to get something simple sorted because everybody is at loggerheads. So these two areas really, really need to look at best interest of the child. And if all of us practitioners also put that kind of effort, and as students or whoever is watching, you learn that early, then maybe we can bring that to the table in courts itself and act in a certain way that will help, because parties are hurt. They have their issues. That's why they're going apart. We as lawyers can't add to it and make it even more miserable than it is. So this kidnapping of children, and that's so much done that can scar children for so long. So this kind of thing, I think, has to be relooked at, and the way it's done, the system itself should be a no tolerance system where anything affects the child's best interest.
Yes, definitely. We should be looking at the best interest of the child as the upper guardian. I think the court also has responsibility to make sure that the child's best interest is kept at the center of whatever decisions that are made. I think we have spoken quite a bit about marriage and divorce and the complexities of family law. And recently there was an article that was published in the Daily Mirror, and I saw this morning even on Pulse, that the number of registrations of marriages and birth are at an all-time low. So I'd like to know your opinion on whether this is reflective of how much faith people have in the marital system, whether people are moving away from marriage, and how can we put the faith back in this system?
So that's a really good question, because when I started practicing, and there was a heavy burden on women's rights and how women were very neglected. And now I don't know whether we've gone all the way and now things are sort of totally out of whack. Because I will admit myself that marriages are not perfect and everybody is not supposed to be stuck in a toxic marriage. But for a community to thrive and for children to thrive, a good marriage and home is important. Having two parents is the best scenario. Unless it's a toxic situation, and then it's better to have one stable parent than two. So the fact that there is an 8% I read reduction from 2023 registrations to 2024, aside from maybe young people have gone for work and things like that, I hope it has nothing to do with a lack of trust in the system itself. I think because it was made so messy, I don't know, our country doesn't look at, culturally, we still don't look at cohabitation as much of an option. I don't know if those numbers have increased. But if it's just a disillusionment from, like, they don't want to sort of, they're so disillusioned by marriage that they don't want to get into it, that's a sad state of affairs. Because how families are directly reflects how strong your community is. Marriage may not be for everybody, everyone can choose to. There's no shaming to it. But solid marriages and families will definitely help how strong a community is. And the fact that young people may not be interested, and I've noticed also the younger people now sort of giving up very fast, is probably just to do with how things have changed. Everything is quick, everything is app based. You get into love through your apps, you get out also at a touch of a button, sort of thing. Is a little bit sad. We went from saying don't trap us to now saying maybe we shouldn't be allowed out so easy, because marriage is work, it's two people trying to live together. And I would say maybe it is on us, the profession, to give back that trust and faith that this is a good institution, and if you want to go your separate ways, you should be allowed to. So something that I've been noticing, I'm so glad that now internationally it has become an actual thing. I was noticing a lot of older people coming to divorce court, taking on matrimonial actions. When I started my practice, I'd say I never saw too many people in their 60s or in their late 50s coming to divorce court. It was sort of like, I'm done, like, what's the point of it now? But recently I've seen it, and it's globally referred to as the gray divorce, because the gray hair, at the gray hair stage, you are getting the divorces. Now, the issue here in Sri Lanka is when you live like that, you have no access to your monies, your properties. You can't leave because you're stuck. And these are some of the reasons that maybe the younger people don't want to be a part of this institution. There's so many tax benefits, other things, community-wise, good for children. Psychologists say having two parents, always good for children. All of that apart, I think we need to look at, there's lots of cases I look at postpartum stage. There's not a lot of conversation around postpartum issues. And so women have certain issues they face right after a child. And then I've seen a lot of divorces happen at that stage. I've seen a lot of happen at this gray divorce stage. And so I think there is a lack of faith also, aside from our numbers with young people also being less in the country. And maybe it's time to actually have more counseling, more mediation, more trust built around it, and more faith put into the system, so that people will act, and more effective domestic violence laws, more effective stakeholders, more effective first responders. So people know, even if I have an issue, it will be remedied. If I call a hotline, somebody will help me. The police will assist me. I won't be stuck till I die in this situation. That will probably help with encouraging the numbers. But it's very sad to see that like an Asian country like ours has almost a 10% reduction in registered marriages in the last year.
Thanks for sharing that. And like you said, yes, we need to see, I think there needs to be more recognition of women's rights, and there needs to be this fear that's taken away from getting into a marriage, for people to have faith in the system. So I'm just going to invite the audience to just add their questions to the Q&A box. And we are going to move straight into the questions. We already have about 5 questions to answer. So it's also kind of like a refresher of everything that we discussed, because I'm going to start from the top. So we have one question saying, please detail the legal age of marriage for male and female under both cultural and general law.
So the other customary laws and our general marriage ordinance allows for 18. There is no difference when it comes to gender. It is only the MMDA where they're trying to really reform it, where I think it was allowed at any age where a guardian can consent for. And that doesn't sit well with the majority age for the rest of our systems. So otherwise it's a general across the board, an age of majority that allows you to get into a contract of marriage. But just the MMDA, that where there are child marriages also, with consent, which they are working at doing away with.
So we also have one question. I think we discussed this, but maybe if we can elaborate a little more. What are the developments in the law envisaged for reforms in marriage and divorce?
So there are lots of reforms that have been put forward, more grounds for divorce, a no-fault system. All of that was encouraged. There's heavy reforms in the MMDA itself, because right now, unless it's to do with custody and unless it's to do with an appeal, you're still within the Qazi court control. And sometimes that differs from how the general acts and the general law gives orders. So now there's lots of MMDA reforms. I know in the community there were different over the spectrum. There was conservatives to very liberal sort of views on how to reform that. So those have been put forward. Tesavalama, there were some reforms also put forward about holding land and things like that. In the general marriage ordinance and divorce, the main thing to be looked at is more grounds they were looking at. Domestic violence was also going to be reformed, where there is no compulsory counseling sent to, because sometimes when there are issues between the parties and they're sent for compulsory counseling, that can worsen the issue. And also third parties can complain when it comes to a domestic violence issue. It doesn't have to be the party itself. And to do away with things like in the fault-based system, and to go for a irretrievable breakdown of marriage, where that is enough, and if both parties are consenting, to simply get out of it without pointing the finger. All of those reforms have been put forward. There was very heavy matrimonial reforms put forward, which I think in due course will turn into legislation.
Okay. Thanks for that. Thanks for that enlightening response. So we have one question which says, what may be done in terms of rectification to make a marriage legally valid, wherein it has been entered into with impediments?
Are they meaning that if you're meaning that it has only had the customary section, then you will go into a registration? If there are other impediments like bigamy, then I don't know if we can advise retrospectively to correct things like that, because it makes it faulty at the time of the second marriage. But if it is about customary aspects, then you can at any point get into a registration, which from that point on will make the marriage legal to a general law aspect.
Got it. Thanks for that. So we have one question. I think we didn't touch on alimony. Can the parties plead for alimony or any sort of compensation in cases of annulment? I would also ask if you can maybe touch on how it would work in divorce as well.
Yeah. So alimony in divorce and annulment both can be asked for if you can show the fault of the other person. It is more awarded in the divorce context, where it's actually sort of like a one-year. It's basically compensation for what has happened to you. So if there's been a third-party interference, you can even ask for alimony and some of that compensation from the third party themselves. If somebody has got into the marriage without telling you about their physical health, then that also you can ask for compensation. Where it is malicious decision, somebody has just left you and not taken into consideration the years you put in the marriage, you can ask for compensation. It's treated as compensation. There is no real quantum to it. It depends. Recently, there was a case of adultery where there was a 25 million alimony. I've heard of much less also. When annulments, we can pray for those, but annulments generally it makes the marriage completely invalid, and so alimony takes a second seat sort of. But in marriages specifically, the fact that somebody has given their best years, and because of somebody else's fault, you can prove that it's because of that person's fault now that I have had to leave this marriage, and now I have to completely go back to being single and taking on life from day one sort of. You can ask for that compensation. But like I said, the quantum differs according to what generally what people ask is also what they think their spouse can afford. More severe the matrimonial fault, more amounts of alimony is asked for, things like that.
Got it. So thanks for answering my question and the participants' question as well. We also have a question about adoption. and where adoption would land in the subject under this discussion?
So adoption is a very, very central part of family law. Matrimonial actions aside, it's very much a part of family law. I'm a big fan of adoption because Sri Lanka as a system has a lot of children that can do with nice homes. I think we have an act that passed through foster caring also. But permanent adoptions are always fancied more because it gives the child more stability. And I don't know why, as a culture, we don't do it enough. I think we take so much pride in our genes that sometimes people don't really opt for adoption. But I think I would encourage anybody who can. It's the nicest thing for you and for the child themselves because there's so many beautiful babies out there. And our system of adoption, and I don't understand this at all, but even our international adoptions are made very, very complicated in the sense that there's a lot of red tape. And I mean, it's fair enough because what probation wants to know is that these children are not going to be scuttled or trafficked out of this country and then misused. But I think, in light of the fact that we have so many children that can gain good homes, and the older the child gets, the less potential. In the sense that most families look for a child under a certain age. They say up to 5 years, a child is cerebrally very influenceable. As in, you can change. There's a lot to do with nurturing up to 5. After 5, sometimes children are set in their ways. So a lot of people like smaller children. So the more delayed the system gets, these children then are in children's homes till they are the age of majority. So I would say it needs to be a more efficient system. Judges also do a lot to make sure the child is safe and all of that. I have seen a lot of international adoptions also, things that I've been a part of, take too long. So maybe probation needs to be assisted in that manner so that if we make it efficient, maybe more people will adopt. And it is one of the best things for a family and for the system itself because then the system has less of a burden of raising so many children in a sort of where we're under resourced and we don't have those kind of budgets and the children don't get the best facilities. So it does definitely come within the family law scope and we have good laws, but the process itself is sometimes slightly lengthier and more complicated, which should be reduced.
Thanks for that. I agree. I think an adoption case can be very daunting, and for a family that's trying to integrate a new baby into their life, it can be really traumatic and also not something that they want to do in the first few years of a baby's life. So moving on, we have a question about whether we see a difference in attitudes of judicial officers in relation to divorce and domestic violence when you compare courts in major cities versus rural areas? And if so, how can these attitudes be changed?
So I don't know how far I can comment on judicial officers, but I know there's been a big change in thinking from the time I started my practice to now I'm 15 years in the practice. I've heavily always been a part of the family law and gender spectrum of litigation. I can see big attitudinal changes and like a lot of training has gone in. But yes, rural areas definitely take on their cultural aspects. So I'll give you an example. I think Shemindri was also it was her organization that got me to be a part of the training when we train the police. One of the big issues I have with the police is them always trying to sort out domestic violence and send the person back. But something I learned from them and having an open conversation with the police was sometimes why they encourage it is if they send the man out of the house on the domestic violence issue, this family is at risk of being attacked or being harmed by other men and other people who can now enter because there is no head of the home, and that aspect was a protection aspect that they were looking at. So there are lots of actual practical difficulties also. I was told once that somewhere in the east or north there was a court where if you suffer 3 incidents of domestic violence you can get a protection order, which is not a part of the act. One act is enough, one act of violence is enough for you to get protection because nobody is here to be beaten up and that kind of thing. So yes, rural areas will probably take on their norms and their culture, which is understandable. But I think the law needs to be enforced in a very similar manner. And so Colombo also has sometimes, or even the greater cities, they have a general understanding of non-contested divorces. But sometimes the rural areas, judges will ask, you don't have a good enough grounds, so I'm not going to give you a divorce kind of thing. But maybe the city areas, they understand that kind of trapping them when both parties want to leave is not going to make any sense. So there are those slight differences, but in general, judicial officers have been trained similarly, and I see a lot of advocacy on their part now, especially the young magistrates and the district court judges, which is nice to see, because for an area like family law, if you just allow it to us to be adversarial, it doesn't help.
Yes, thanks for that, Jerusha. I just want to say thank you to all the participants that are sending in questions. We have a lot more questions to answer. There is one question on prenuptial agreements and whether they are valid in Sri Lanka and whether they can be legally enforced.
So sorry guys, at this moment it is not valid per se. Our courts and our laws like separation agreements, things that you do at the end of the marriage to amicably maybe even divide your properties and things like that. But prenup, what they think is that, and I kind of get that, thinking of the end at the beginning or before marriage then kind of spoils the whole sanctity of marriage. So in that sense, there is no black and white law saying prenups are enforceable within our jurisdiction.
Got it. Thanks for that. So moving back to adoption, we have one question about whether unmarried women could adopt
So
a
generally
child.
there is a thing about single moms that have not been allowed, right? Which I also don't understand, but that has been sort of maybe the whole cultural aspect. Plus there is something in the act about two parents having a preference. So yeah, so that still stands, and single moms are not given that benefit. And the other thing is age also. There has to be a 21-year gap between the child and yourself. And couples are given preference unless there is something to show that you are the next of kin and things like that. Single parents don't get that kind of privilege.
Thanks for that. I'm just trying to pick the next question. So in cases of bigamy, can the DC matter continue concurrently with the magistrate's court matter?
So it does, and you can also claim that as a part of your case. And if that grounds is then proven by the criminal court, then obviously your civil court matter becomes much easier to prove. Like I said, it's treated criminally, and there's an arrest to it, and then people have to prove and all of that. So it's treated very seriously. Yes, it can become a part of your matter, but that's not grounds for divorce. It's grounds for annulment, and you can then switch it up if that has been proven.
Got it. Thanks for that. I'm going to combine. Sorry, go ahead.
I just want to add, because if that is proven, then your marriage never took place, is what they're trying to say.
Okay. I'm going to combine two questions. So how the no-fault dissolution happens and what countries use no-fault dissolution of marriage and how the concept of irretrievable breakdown of marriage have evolved in the modern legal systems. So if you could just maybe answer those two together, I think.
Yeah. So irretrievable breakdown was always sort of like the umbrella branch, and under that came the faults. Even the UK laws had the similar thing. Now, irretrievable breakdown is standing alone now so that we don't have to prove a fault. That is how it has evolved. In terms of what jurisdictions, widely, almost in all jurisdictions except some of the more conservative countries, no fault is allowed, because it's understood that as freely as you can enter into this, you should be allowed to get out of it. So now it's widely spreading in all the countries, including the countries where we potentially got this law from. Irretrievable breakdown itself is like the umbrella branch. For no fault, it stays as the only grounds to prove. For fault, it stays as the umbrella plus a fault that you will have to prove. So how it has evolved is, back in the day, it was that plus a fault. Now it can be standalone in the no fault area of law.
So there's one more question which says, what is the process if the parties were married in Sri Lanka and they now live abroad and want to seek a divorce?
So as I told you, even if they do have lived there for a bit and they can go to those courts, we still don't automatically accept other jurisdictional divorces. So it has to be filed here again. I think it's because of that a lot of people prefer to file it here once and for all, because sometimes getting this validated in a foreign country is easier than the other way around. But like that's a part of the reforms also, and once that takes place, there will be that sort of system where if you have a foreign divorce, you can very easily get that validated here. But for now, because that's not accepted, a lot of people prefer to file in our courts itself so as not to duplicate matters and have it in both courts. But if you've lived overseas for a long period of time, then that gives you a right to go into those courts for any family law issue that you have that is happening at that point in that country.
Okay, so there's also a question speaking about a recent trend of divorced couples coming back together after a period of time. Is there anything that prevents a couple from remarrying after a divorce?
It's not a recent trend. I think it was Elizabeth Taylor or some famous actress like that who married the same guy 3 times over. I feel like we make this so bitter that a lot of people won't come back together. But if it is not so bitter, maybe people find themselves back. Maybe that break, maybe that they didn't really need an official or a judicial break. Maybe it should have just been time apart to fix things. There is no bar. You can remarry anybody for how many times you like, and that is not frowned upon. And there have been many cases like that. And a lot of people, I think, I've also noticed that if things are mediated properly in a divorce, then those parties' relationships anyway improve a lot right after that. It is only during this stressful court period that people really get to their worst. And I can only imagine the kind of trauma it causes people. For us, it's we go to court every day. It's not something scary, but for people to actually come there, take those boxes, give witness statements, and to be just hassled like that is a lot of stress. So generally, this kind of trend of marrying the same person, it has happened. Not that it hasn't.
I'm going to ask one last question from the Q&A box. It's not very relevant to the discussion, but I think it might be something for us to touch on. While it's not under the subject of that's being discussed, as a family lawyer, could you elaborate on surrogacy?
On surrogacy. So here also, there is enough validity for it to happen. The only thing that you need to know is that it cannot be like a business, a paid for sort of thing. It's not frowned upon in the sense that if some surrogate and everybody has an agreement, it has been accepted in a lot of cases. We don't have a lot of black and white law to it, so surrogates' rights are sometimes compromised because it's a health factor and people put themselves in good faith, but it can take a turn, and so insurance policies and those kinds of things have still not become common here. But what ethically our laws look at is that it's not a business, that someone is now not carrying children as a business and they are not given some kind of remuneration above what they have suffered, so that it doesn't become like an incentive to carry things like this, because what they think is then the whole social and cultural part of it will be affected. But other than that, if the parties have come to some kind of agreement, courts generally has been happy to see through the adoption and things like that, as long as these unethical practices are not used.
Okay, thanks for that. So I'm just going to do a quick recap on the session today. We started off by talking about registration of marriage and the system of registering marriage in the general law and also the personal laws. And we discussed how it differs from the general law and that they are formally recognized. And it's also, we spoke about the importance of mediation in terms of when a marriage is ending, how mediation can be used as a tool to move away from the adversarial court system to make it a little bit more humane. Also, we spoke about how domestic violence can be made into a ground for divorce to ensure that the victims are not trapped in an abusive situation because of the fact that currently the law does not recognize domestic violence as a ground for divorce. In terms of custody and maintenance, it's important that we look at the best interest of the child in all stages. Similarly, we discussed the importance of legal aid and sensitization of stakeholders that are involved in family law cases, like the police, JMOs, and also the lawyers. And then also we have seen that there is a fear of marriage or being stuck in the marriage, which we think may have led to the trend in the low number of registration of marriages and birth in the recent years. So before I finish, I just would like to ask you one more question. If you could share maybe some advice for lawyers that want to get into the field or already in the field of family law on what to expect and also what has worked for you.
So basically, one of the things I've noticed that this is a very different sort of sphere. So your thinking should not be about winning at any cost. It's different. It's not like a criminal law case where you are justified with punishing the other person, or like I said, a commercial big money case or a land case. This is a home-based case, which at its best, handled at its best, changes the entire status quo of a family and affects the children for a long period of time. So if you're taking on family law, having some kind of study or knowledge of psychology is important because it's a people's thing. It's the most, they say employment law and family law is the most personal for your litigants. So sometimes you feel like you're sometimes counseling litigants because even for them to get to a certain place or even come to a certain decision, it's hard. So unlike any other kind of law that you practice, this you have to think of in that manner. You have to leave people, their families, even if they're going apart, better than you found them. Because what they bring to the table is a lot of stress and a lot of anxiety, and rightfully so, because you can handle anything outside if your home is stable. But if your home is now undergoing some kind of shift and a status quo change, that is probably the biggest stress that you will suffer. So I would say to young lawyers and people who want to get into matrimonial actions and even matrimonial and divorce laws, that you look at it with grace and that you are able to leave them better than you found them. And I have been very honored and very privileged to, in my 15 years of practice, mostly meet opposing counsels and a lot of men also who are really nice and easygoing when it comes to family matters, and they want to do the right thing. They want to finish it off in a nice way because everybody can relate to this. Most people have a family, come from a family, and you can relate to it. So that aspect of a human, empathetic sort of way of thinking is very important because this is not a place where, like a rape matter or something where you are justified in sort of bringing the hammer down on the other person. Even if there is a person acting wildly in this matter, it is still your client's child's other parent. And so that needs to be thought of in how you regulate these matters and leave it better off. That being said, you have your difficult cases and your easy cases, and then you have to do what you have to do. But that kind of aspect of a more rounded way of thinking and a more mediation way of approach than an adversarial approach is extremely important, because sometimes the system can give you very little. You can go and file 6-1 applications and ask for this and that and the other, and if the other person is being nasty, you may not get as much access as you want for years. But who does it affect? The child, because the child is missing out on one parent. On another side, it could be that maybe somebody is wrongfully using that kind of time with the child, and then you are unable to preclude that. There is all sides to it, but like I said, you have to think about it in a rounded way, in an empathetic way, and you need to be built to handle that kind of thing because it takes more time, it takes more listening, and you have to leave your emotions behind because the parties will anyway bring all of that to the table. So your job is then to present it in a way that is wholesome and holistic and doesn't have too much emotion to it, because you want the best thing done for the case. So it's a very different kind of practice, and I guess you like it or you hate it. But if you're built for that kind of thing and you come from a background of where you are used to working with people and things like that, this is a very interesting area of law. As much as it's different and like sometimes exhausting, it also is very gratifying because every single day you get to at least try to do the right thing by somebody and their family and leave somebody better off than you found them. And I guess that's what we are all trying to do as lawyers anyway. So it's a very interesting and gratifying area.
Thank you for sharing your advice, and I agree with you. It is very rewarding to be working in this field. And I've worked with you closely to see you on your feet and also in court and how you handle clients. And I think it's really important that you handle your clients well, especially when emotions are high, in cases of divorce or domestic violence or family law. So that's all. Thank you so much for sharing your insights. It's been such a great discussion. I think everyone here has learned something new today, and we're going to embed that into our work. So thanks again, and over to you, Suri.
Thank you. This brings us to the end of the 17th webinar of the series on Basics of Law titled Matrimonial Actions. I thank our esteemed panelists, Ms. Jerusha Crozet-Tambaya, Attorney at Law, and our moderator, Ms. Shevindri Manuel, Attorney at Law, for the fruitful and educational discussion and for dedicating your time to be here with us and sharing your insights. I thank the BSF Webinars and Legal Symposiums Committee for their dedication and hard work in organizing this webinar. I also extend my thanks to all the participants who have joined us today and for making this discussion very interesting and engaging. And I thank you all and hope you have a very good night.